power of attorney forms and advance directives. A local lawyer who is a member of the National Academy of Elder Law Attorneys helped make sense of the jargon tossed at me by most of the health professionals.
Hello, I'm Attorney Raleigh Hansen, and I would like to talk to you a little bit about estate planning and the proper documents to... Now, the general durable power of attorney for finances allows a person to appoint an agent to carry out and manage their assets in the event that that person is no longer able to do so. So if, for an elderly person, if you become incapacitated for one reason or another, it's desirable to have a properly executed and witnessed financial power of attorney to allow your agent to carry out your wishes and to help preserve your estate. In cases where an elderly person has been declared incompetent by a doctor and because of a traumatic event or some debilitating illness has to go into a nursing home, if there is no properly executed power of attorney for finances, that individual would not be able to preserve assets for their beneficiaries. In other words, their assets would have to be used, all of their assets would have to be used to pay for nursing home care. Another thing to understand about this document, as with any power of attorney document, is that the signing of the power of attorney does not mean you are giving up your rights or relinquishing any power over your estate. Rather, you will maintain in more control over your estate because you can appoint an agent to carry out your wishes in the event that you do become incapacitated. And of course, one of the very important estate planning documents when you're talking about Title 19 issues can be the financial power of attorney. Because if an elderly parent, for instance, is going to have to go to a nursing home, or if they're in a nursing home now, they may reach a point where they're not going to be able to make financial decisions for themselves, and they're going to want to have somebody else to make those financial decisions for them. And that may include doing some asset protection strategies or some type of divestment strategies to protect some of the assets, rather than to just have all of their money go for the nursing home care. Another thing that's important to understand is the health care power of attorney or the financial power of attorney will not become activated unless you are incapacitated and no longer able to manage your financial affairs. Some people are concerned that once they've signed the power of attorney, that they have appointed an agent and they lose control of their assets or of their decision-making authority. This isn't true either, because the healthcare or financial power of attorney can be revoked at any time by simply writing a letter to the agent. For an elderly person, this means that if you appoint someone to act on your behalf and you do change your mind later on, you can unilaterally revoke the power of attorney and take the authority away from the agent again. I mentioned a couple of times the healthcare power of attorney. The healthcare power of attorney is important because it allows you to appoint an agent to carry out your wishes or desires in regard to medical treatment. Some people will advise their agent, for instance, that they do not want to be kept alive by artificial means. And while this is not a pleasant thought, this is still something that's in the realm of possibility for any of us, and even more so for many elderly persons. The ability to have your wishes carried out and maintain the kind of control you want in the decision-making process is part of your decision to have a healthcare power of attorney executed, and doing it while you still have a chance to think about it and are not rushed, or that you're not faced with a traumatic event. It is a much better, more balanced, reasoned way to carry out your wishes. Many people will also include a provision in the healthcare power of attorney to allow their agent the authority to have them admitted into a nursing home if necessary. Now, the advantage of having that kind of provision will alleviate the need for a guardianship. And it's much, much less expensive, much less cumbersome, and much less traumatic for the family if you have the healthcare power of attorney document drafted. Another point I would like to make is you can protect assets if you are faced with a situation that you or your spouse does have to go to a nursing home. And the same is true for an individual with no spouse. The opportunity to protect assets is always there, and basically the divestment strategies available can be implemented. In many cases, people will have a divestment strategy or an asset management strategy developed for them by an attorney, or they'll seek legal advice as to what they can do. Now, the sooner that you implement or at least become aware of how the law in this area works, what your exposure would be if you have to go to a nursing home, and what you can and cannot do to protect assets, will give you a lot more power and more discretion in doing the proper planning for asset preservation. But it's important to note that it's never too early or too late to do some asset management planning. And some people are faced with having to make these kinds of decisions even when they're going into a nursing home in a week or two. This also relates back to the general durable power of attorney for finances. You can draft this document and provide authority for your agent to preserve assets by carrying out a proper divestment strategy. Many people will want to consider this because, again, if an elderly person has been declared incompetent and they do not have the general durable power of attorney executed prior to that time, it may be too late, and frankly probably would be too late, to have the general durable power of attorney for finances executed to carry out any desirable asset management strategies. A properly executed and witnessed will is one of the most basic estate planning documents that any estate planning attorney would advise you to do. Now, in addition to a will, some people will use a living trust or some type of trust document if they desire to avoid probate. This is another consideration for anyone that has collected assets or property over the years. And this is also a concern that could be discussed with an attorney to get the proper feedback and advice as to whether a will or a trust would be more desirable for your particular case. One of the big advantages in consulting with an attorney is that you can get any and all questions answered, and you can have them answered by a person with the proper training and expertise to give you the right information. In conclusion, I would like to advise you or advocate that you do your planning ahead of time before the day comes that you are beginning to have significant health problems. The estate planning documents are like an insurance policy. They're there to take care of your interests and carry out your wishes just in case.